This video covers Chapter 10, Transfer of Property, and there are 4 possible questions on your exam. Goes by pretty quickly. Just to resolve your fears, as all of these chapters, I expect you to read over, do a cursory review of the material. I know it seems a little complicated, but there are only four possible questions. They actually had a higher number of questions on this chapter, but I'll explain it pretty well, and I think you'll have a good handle after I go through the lecture. First, let's go to deeds. I'm going to go to the board here. The title says transfer of property. There's a couple different types of transferring property. If this represents ownership, you can transfer your property either in these different ways. These are considered voluntary. When you voluntarily transfer your property, that means you want that to happen. You've got by will, you can transfer it that way. We all know what that is. We can sell it, voluntary transfer. If the government takes it, if you go back to some of your previous chapters, that is either escheat or maybe eminent domain where they take it. You know, you have to have just compensation, and it has to be for the public good. Or a bank takes it. Well, in a bank situation, if the bank's taking your property, that's probably involuntary. It means you haven't paid your mortgage and they're taking it back into foreclosure. So you've got this section. And this is not the only way, but these are the primary ones. A government or a bank taking it, and those would be considered involuntary. Now, I know you might agree to an eminent domain, but it's just not something that you've gone out and said, hey, I want my property to be sold to the government. All right? These are the different types of deeds, so you need to know the characteristics of these. General warranty deed is considered the safest deed. When you take title to a property, this says, and I use this little line, this means the seller guarantees title all the way back in time, and it also means that I will guarantee or help with further assurance. Essentially what that means is that if documents need to be taken care of or satisfied, I will help out in any way I can in the future. Maybe if there's a missing document out at the closing, I'll be happy to sign something to continue that or further assure good title. Special warranty deed only is a deed that you receive, and the seller is only saying, I only promise good deed from this point to this point, from the time that I owned it. That's the second one. The last one here is called a quitclaim deed. We reviewed that earlier in an earlier chapter that said it's really designed to take care of clouds on the title. So that's what its primary use is. So let's go back to the material. Starting out, A, deed transfer of title on page 119. A2, when a person dies intestate. That means when you see the word intestate, that means they do not have a will. Testate means you have a will. So if you die intestate, the decedent's real estate and personal property pass to her or her heirs according to statute. When you see a question that says the property was distributed according to statute, that means that the state took it and they're going to distribute it out. So those are some operative words there. By will, go to 1, by will, or B2. State laws usually require that on the death of a testator, his or her will must be filed with the court and probated to pass title to the devisees. Although title upon death automatically vests in such devisees, will or intestate title to property may not be in abeyance. Well, don't get too wrapped up in that. Know that even with a deed, or rather even with a will, they still have to go through probate. The probate courts look at the will and they determine, how the real property or the possessions can be transferred. C, involuntary alienation. Well, that's a fancy way of saying someone's taking your property, some entity's taking your property involuntarily. All right. First one, we've discussed this, is cheat. You die without a will, it leaves no heirs, then it goes to the state, and it's determined that way. 2, again, this is repetitive. This chapter, some of this is repetitive. 2, eminent domain. The federal, state, and local governments may take private property for use, or for public use through a suit, they do that, and this is important that you know this, so highlight or underline, condemnation. So when they take the property through eminent domain, they call it condemnation proceedings. Owner must be given just compensation. 3, to satisfy debt. Debt is foreclosed, the property is sold, and the proceeds of the sale applied to pay off the debt. That would be a bank going through foreclosure. Next page. D, that's top of 120. D, voluntary alienation. Okay, this is how we pass real property through a couple different deeds. Go to 1A, and that describes what a general warranty deed is. There are certain promises. We're going to read through some of these. I'm just going to highlight just a few little words as we go down these. The general warranty deed, when you see the term covenant, input the word so you understand it, is a promise. So, number 1, provides the greatest protection of the deed, and this is we're discussing the general warranty deed. There's a covenant of season. The grantor has title and possession and has the right to convey. Season means you own it fully. The next one is covenant against encumbrances. That means it's free of any liens and encumbrances whenever you transfer. So that's why they say you pay off your loan and then you go and you transfer your property. The next is quiet enjoyment. The grantor guarantees the title is good against any third party. Further assurance, it says the grantor promises to obtain and deliver any instrument required to make the title good against any third parties. So that's kind of a promise to say if anything goes wrong, I'll be happy to go ahead and sign or do whatever I need to do to make it right. Go to B, special warranty deeds. The only thing you really have to remember is that special warranty deed, if you receive a special warranty deed, the conveyance only promises during the time that they owned it. It might be 6 months, it might be a year. Usually corporations will transfer by special warranty deed. Then the last is D, quitclaim deed. It carries or contains no warranties and conveys only such interest, if any, the grantor may have when the deed is delivered, but conveys the interest completely, often used to cure defects in title. So it doesn't really transfer, or there's really no guarantees with that. It just says, if I have any right to this property, I'm quitclaiming it to someone else. No promises. E, types of proof of title. Number 1, Oklahoma is an abstract state. 1A, abstract of title. What is an abstract? Well, there's abstract companies in Oklahoma, and what they're charged with is filing every document that has anything to do with a piece of property inside this big, thick book that's called an abstract. Some of them can be several inches thick. It's pretty much a history of that property going all the way back to when whatever Native American tribe took it over in the state of Oklahoma, and there's all the different documents that affect that property. Abstractors have these big books. They file them, they keep them on file. Whenever you need to transfer your property, they bring them up to date. They send them to the closing company. The closing company, they seal it, they add whatever they need to. They go back to the abstract company, they and then they store them until you transfer it again. So these big, thick books are essentially history lessons. They're really, if you get a chance to read an abstract, do, because it's a fascinating history of events in there. But it's everything that they do, or everything that has to do with that particular property, they put all those documents in there. So they bring that up to date. After that, during this process of when you're closing the property, they send it to an attorney. The attorney renders an opinion. And the opinion pretty much is everything that's in there that it should be in there is there. It's present. They review it, and then they render title insurance. Okay? Go to F, which is page 121, top of the page. What is title insurance? That's F1. Title insurance protects insured against loss resulting from certain defects in the title, such as a forgery or defect in the public record, other than those exceptions listed in the policy. What this does is if you have any problems with your title, now or in the future, title insurance kicks in and they help indemnify you. What is indemnity? Well, that's where F4 comes into place. It is an indemnity contract. An indemnity contract doesn't say, we will guarantee you will have title to this property forever. What it does is if anything catastrophic occurs and someone else claims that title and they have legal right to, then the indemnity contract helps you be whole again. So it actually gives you maybe whatever your loss. So it doesn't guarantee you keep your property. What it does is it helps you indemnify your loss. All right? Go to 3 on that same page, Roman numeral 3. Requirements for valid conveyance. Here are some requirements. Here's a couple things you'll need to know. Number 1, grantor seller must have legal existence, be of legal age, and be legally competent to convey title. Go to number 7, signature of grantor. Must be signed by the grantors named in the deed. Sometimes a seal is required. What we want to do whenever we transfer property, we want to have at least the signature of the grantor. When you hear these terminology, and I say grantor, grantee, mortgagor, mortgagee, the or is the giver. The E is the receiver. So when you see that, then you can say, okay, who's receiving something and who's giving something. In this case, the signature of the grantor would be the seller. So that's one that we have to have the seller on the deed. The grantee does not have to sign the deed. Just need to have the seller. So what we're doing is we're proving that the seller intended to sell this property. Number 9, delivery and acceptance. Actual delivery of the deed by the grantor and either actual or implied acceptance by the grantee. There's questions on the exam that might state, they closed on the property on Friday, they got the deed delivered Tuesday. When was their valid conveyance? It's not on Friday, it was whenever they did next Tuesday, whenever they delivered it to next Tuesday. So that's very important that you know that, because it might throw you off unless you realize that conveyance didn't occur till 3 or 4 days later. Go to page 122, 4, and then A5. That's about middle of the page. Legal versus equitable title. 5. Many states have adopted a Uniform Vendor and Purchaser Risk Act, which states that the risk of loss shifts to the buyer only if possession or legal title has been transferred to the buyer. What that does is whenever a person purchases a property, there's that 40 days we talk about, that in-between time. If something goes wrong with a property, then it's still the seller's responsibility to get it taken care of. If it has a fire or burns down, it's still the seller's responsibility. But when they close, then now it becomes the new owner's property or the buyer's property, and then all risk is on the new owner. The exception is, or the other example, is if the new homeowner or the new buyer occupies the property prior to closing. Sometimes they do what they call an early occupancy. It's kind of frowned upon, but if they do an early occupancy, then at that moment the buyer takes full responsibility. So the Uniform Vendor or Purchaser Risk Act says anytime prior to closing, it's seller's responsibility. The buyer moves in or closes, it's their deal. Okay, B, we've discussed this before, equitable title. The buyer has equitable title during the process, from the time they have offer and acceptance to the actual closing or the deed transfer. Number 5, Real Estate Settlement Procedures Act, also known as RESPA. Go to B3. Two elements you need to know. The loan closing expenses must be prepared on a uniform settlement statement. They call that a HUD-1. So when you get a closing statement or a settlement statement, they call that a HUD-1. Last one, 4, is RESPA explicitly prohibits the payment of kickbacks and prohibits referral fees when no services are actually rendered. Okay, what you cannot do is go to a lender and say, hey, Bill, with ABC Mortgage, Bill, I tell you what, I'm going to give you 10 loans, and for all those 10 loans, give me 25% of your, give me $100 for each loan. Can't do that. Same way that a lender can't pay you as a licensee money to give them business. You can't do that. It's called kickbacks. Okay, you're prohibited from doing that. We want the consumer to decide on that. Now, a lot of the times the consumer doesn't know anybody. They might ask for recommendations. That's perfectly okay. You just can't go turning around writing checks to people that are giving you business that are part of the Settlement Procedures Act. All right. That concludes Chapter 10, Transfer of Real Property.